Today we're going to play a little segment called Can I Sue? I'm Melanie Weisbecker, Director of Operations at Awad Baker Law. And here are our two contestants for the day. Please introduce yourself.
Hi, I'm Alexandria Awad. I'm a senior trial attorney here at Awad Baker Law, and I'm also the manager of our Buffalo office.
And I'm Veronica, the medical malpractice managing partner.
Okay, first question, ladies. Can you sue if you weren't wearing a seatbelt?
Ding, ding. Yes. Yes, you can. Of course you can. Right. You can sue even if you weren't wearing a seatbelt. I mean, it's not great that you weren't wearing a seatbelt. I don't know why we're not wearing seatbelts in 2026.
I watched a lot.
But certainly you can still bring a case.
I watched a lot of Jeopardy.
It's going to be used against you, obviously. You're supposed to be wearing a seatbelt. And in New York now, you have to wear a seatbelt, I think, in every seat in the car, even in the back row. But what's going to happen is that it'll be used against you, and that whatever you are awarded or any recovery you make, a jury is going to be allowed to deduct from that what they find you to be comparatively negligent and say, well, if you had been wearing your seatbelt, maybe this, and this wouldn't have happened. Or maybe you got all these injuries were way worse because you weren't wearing your seatbelt. And a jury is going to be allowed to assess a percentage of fault to you, and that percentage is going to be deducted from your reward.
And as Veronica said, you can still sue even if there isn't a police report.
Great. So the short answer is yes,
car
you
accident
can sue.
cases, especially
The good
since
answer,
COVID in
better
New York
answer
City,
is
you
you
call
should always wear a
NYPD, they won't
seatbelt.
come unless it's a serious accident with life-threatening
Next
injury.
question,
So
ladies.
oftentimes, I got rear-ended myself.
see who's
under the table.
I thought it was serious. No one else didn't think so.
Hands under the table.
I watched a lot of Jeopardy. That's just the nature since
All
COVID.
right,
is
next
that,
question. Can I still sue if there
isn't
isn't a police report?
As Veronica said, document everything,
Ding,
take
ding, ding,
pictures.
ding.
You can also
Veronica
submit
got this
a
question.
form, your own. You can
Short
fill out your own
answer,
accident report.
yes,
submit
you can
it.
still sue
And
if
the
you don't
same
have a
thing
police
goes for,
report. And
construction
again, the
site
better
accidents,
answer
or if you
is the
slip and
case is
fell at your
always stronger
apartment
and
building,
better
things
with
like
the
that.
police report.
Make
But
timely
if you
reports
do not
of it.
have a police
That
report,
helps
make
to
sure
go,
to
one,
take
to preserve
photos
your evidence,
of
and two, to preserve your
everything.
credibility.
Get all the
Because
information,
if I
license
fell on
plate,
a Friday
things like
and I don't
that,
report
the
it till
name,
2
the
Fridays
address
later,
of the
that opens up
driver
the
you're in the
window to say,
accident
hey,
with,
did you really
and
get hurt on this
document
Friday,
everything.
or did something happen in
And then
between?
I
and
will
now you're
add
gonna
to
blame
that
it on
for some
Friday,
bonus
that,
points.
that first incident.
Yeah, and
So it's very
as Veronica
important that
said,
you
you
do
can
that,
still sue
and,
even if there isn't a police
in the
report.
digital age, you can.
That
Everyone
goes
has a
with
cell
car
phone now
accident
for the most
cases,
part.
especially since
Take a
COVID in
picture,
New York
take a
City. You
video,
call
and then
NYPD,
most
they won't
importantly,
come
call an
unless
attorney.
it's a serious
Because
accident with
attorneys are
life-threatening
trained
injury.
or
So
should know,
oftentimes I got rear-ended
that
myself on
evidence
Long Island
disappears,
Expressway.
within,
I thought it was
30 days
serious. No one else
sometimes,
seemed to
even
think
less.
so.
So if you
So
don't
no
have
one
a
came.
police
But
report or
that's just the
supervisor's
nature
report,
since
at least we
COVID
can
is that
get
they
back
don't
to
have
the
the
scene and
resources
take
to send
pictures
out
as
for
close
that.
in
You,
time
as
as
Veronica said,
possible
document
as to how the
everything, take
conditions were
pictures.
when you
You can
got
also
hurt.
submit a form, your own. You can fill out your own accident report and submit it. And the same thing goes for construction site accidents, or if you slip
you
and
can take
fell at your
pictures-
apartment building, things like that.
I'm my father's
Make
daughter.
timely reports of
I'm my
it.
father's daughter.
That helps to go, one, to preserve your evidence, and two, to preserve your credibility. Because if I fell on a Friday and I don't report it till 2 Fridays later, that opens up the window to say, hey, did you really get hurt on this Friday, or did something happen in between, and now you're
I'm
going to
just
blame it on
respecting
that first
seniority
incident.
here.
So it's very important that you do that. And
Yes, you can still
in the
sue
digital
if
age, you
there isn't a
can.
witness.
Everyone has a cell phone now,
Obviously,
for
it
the
always
most
helps
part.
when there's someone
Take
to
a picture,
corroborate your
take a
story
video,
and what
and
happened.
then most importantly, call an attorney.
It happens all the time.
Because attorneys
We
are
have
trained
clients who
or should
get
know
hurt, no one's around to
that
witness
evidence
it.
disappears
There's no cameras of it,
within
but,
30 days
what is
sometimes,
important
even
is
less.
making that
So if you don't
timely
have a police
documentation of
report
it,
or supervisor's
even if
report,
you go
at
to the
least we
hospital
can
right
get
away, said I slipped and
back
fell
to the
in front of my
scene and
apartment
take pictures
building,
as
or
close in
call your
time as
landlord, I
possible
slipped and fell,
as to how
this
the
happened.
conditions were when you got
Take
hurt.
pictures, and the
Ding,
next
ding,
best
ding,
thing
ding,
is taking
time's up.
pictures and videos at the scene if you can. If you can't,
That
I've
was a
had
lot,
clients who
sorry.
get
That
taken
was good.
away
That
in an
was good.
ambulance.
Well, you take
these over, yeah.
No, listen.
Laying down on
I'm
the
my
ground,
father's
slip and
daughter.
fall on
Yeah, exactly.
ice,
I'm my
and,
father's daughter.
He can't
You really
whip out his
are.
phone and take
Talk,
a picture,
yeah.
but he can
All right.
either come back
Third
when he's out of the
question,
hospital,
ladies.
or even
Can
send
I
somebody.
still
Or
sue
in
if
that
there
case,
were no
he called me,
witnesses?
and I had an investigator go down the next day
Ding.
and took
Did you want
pictures
me to
based
rush
on
you to the bus
where
end?
he described
No, I'm
where he
just
fell.
respecting
Was
my-
able to
the
FaceTime from the
se-
hospital
seniority
and point
here.
to say that's where I fell, and
Go
then we
ahead.
took pictures the very next
Yes,
day.
you can still sue if there
so
isn't a witness.
The short answer
Obviously,
is yes.
it always
you
helps
can
when there's
still
someone
sue
to
even if there
corroborate
isn't a
your
witness.
story
The longer
and what
answer
happened.
is
But
call
yeah,
an
we have
attorney
it
when
happens all the
there's no
time.
witness.
We have clients who get hurt. No one's around to witness it. There's no cameras of it, but. What is important is making that timely documentation of it. Even if you go to the hospital right away, said I slipped and fell in front of my apartment building, or you call your landlord, I slipped and fell, this happened. Take pictures, and the next best thing is taking pictures and videos at the scene if you can. If you can't, I've had clients who get taken away in an ambulance and, laying down on the ground, slip and fall on ice, and he can't whip out his phone and take a picture, but he can either come back when he's out of the hospital or even send somebody. Or in that case, he called me and I had an investigator go down the next day and took pictures based on where he described where he fell. He's able to FaceTime from the hospital and point to say that's where I fell, and we took pictures the very next day. So the short answer is yes, you can still sue even if there isn't a witness. The longer answer is call an attorney when there's no witness. Call an attorney because they have the tools, or they should have the tools and the strategy to be able to get the next best thing.
All right. Fourth and final question for you ladies. Can I still sue if I waited a week to see the doctor?
Ding, ding, ding. Veronica takes that one. Yes, you can. You can still sue even if you waited a week to see the doctor. The better advice and practice would be to go see a doctor immediately, document your injuries, because it all goes to credibility and your evidence. So you do want to make a documentation of that as quickly as possible. But you can still sue even if you waited to go to the hospital or the doctor. A lot of clients typically think that just because they fell and they didn't go to the hospital or doctor right away, they don't have a case. But that's not true. Sometimes the injuries take time to build. So you might get injured and not even realize you're injured until a couple of days later. That's when your back hurts. That's when your knee's acting up. And so these are things that we can kind of maneuver during litigation and get around. But the better practice is to go see a doctor right away, but you can still sue if you took some time to go see a doctor.
And Alex, do you know of any clients who think, let me just wait it out and see if the injury gets better? Or maybe that's why they don't go to see a doctor right away?
Yeah, and I see it all the time. I see it more than I would like to. I understand that life happens and that you need to sometimes work through pain, and you still got to go to work the next day. You pop a few Advil and aspirin and you hope it goes away, and it doesn't. I understand that life happens. We have plenty of cases like that, especially we represent construction workers who are already, as tough as they come, waking up at 4 a.m. To work a long day shift under, strenuous conditions. I see it all the time. That's why it's important to, go get medical treatment as soon as possible. If it can't be that day, that night, or the next day, at least document it in some way. If you can file a report, if you can even, send an email or a text message to a friend and say, I fell, I slipped and fell, I got hurt, or hey boss, I'm really not feeling that great. I'm still going to come in because I don't want to take PTO for this, but can I do light duty instead? I'm really not feeling well after I fell yesterday. Things like that. It's very important that you document it. And it's also very important that you have an attorney who has experience dealing with what they call gaps in treatment. It's a nice zing term that, the defense likes to say, oh, there's a gap in treatment. There's a gap in treatment. That doesn't scare us because New York City jury is going to understand that life happens and that you need to still go to work. And that's part of your attorney's job, is how to persuade a jury to do that. And we do it quite often.
Great. Really
So
good. Who won? Alex did.
For most words.
She just talks more.
Yeah. And Veronica got to the point quick.
My bad.
Yes.
I always do that.
That's good for the videos. That's what we need. All right. We're going to play another segment right now called Things You Should Never Do at Your Deposition. I have highly skilled attorneys sitting to my right who have so much experience with depositions with their clients.
I'm just kidding.
And they can offer the best advice with their years of experience. So I'm really curious, Veronica and Alex, what are things you should never do at your deposition as a plaintiff, an injured party?
The first thing is you should never guess. Never guess the answer to the question. So if somebody asks you something, don't say, well, I guess it was Tuesday at 4:39 p.m. No, because your guess today is not going to be your guess tomorrow. You can always approximate if you can. So like if you know it happened on Tuesday afternoon, say it was approximately Tuesday afternoon. But the worst thing you can do is guess. So never guess, approximate. And if worst comes to worst, you just don't remember, just say, I don't remember, or I don't know.
What if a client says, I don't remember, or I don't recall too often? Does that hurt their deposition?
So yes. The short answer is yes, because then a credibility issue is raised, right? How is it that you don't remember what you did that morning, but you remember the exact moment of the accident, right? So you don't want to just say, I don't remember. So you do want to try to approximate as best as possible. Obviously, there are some clients who have brain injuries, so I don't remember is actually really good for their case because it highlights and showcases their injury and their damage. But if you're claiming like a knee injury, you want to try to approximate as best as possible because a lot of times it's your testimony that's telling what happened, right? And without you being able to remember what happened, the jury won't know what happened. And that'll kill your case, right? So you want to try to remember as best as possible without guessing.
I would add to that too, another thing that I prepare clients for is don't become googly eyes and friendly with the defense attorney. Oftentimes, if it's a female client, they'll sometimes send a female defense attorney to take their deposition and make the plaintiff feel comfortable. Because when you start feeling comfortable and it's like it seems more friendly than adversarial, the plaintiff is likely to say things that they really shouldn't say, and offer up longer answers that where an answer can just be a yes or no. They start saying yes and this and that, and for every extra, I tell our clients, every extra word you give beyond yes, you're now inviting 10 other questions that are one, useless, or can lead to more questions. So we say if it's yes, it's yes. If it's no, it's no. Let them do their job. Let them extract more information from you. Don't be too friendly. Don't feel the need to fill in silence. Like it's not like you're on a bad blind date and you feel the need to be nice and fill the silence. I'll sit there in silence. I'll eat my food, sit in silence, and just talk when I have to. That's it. You don't have to be friendly with the other side. Another tactic too is that let me, if a plaintiff is talking too much, you're now not only giving details that open doors that should have never been open, but you're also tiring yourself out for the critical testimony. Because the first part of a deposition is usually, hi, how are you? What's your deal? What's your background? Like, okay. And then the second part is when we get into liability. And it's like, well, do you remember which foot you stepped with first? Do you remember who else was there? Do you remember seeing that defect before? Like, those are critical questions. And if you're talking too much in the first chapter of the deposition, then you're going to be tired and you're not going to be sharp for what's really important. So I say, yes, if you can answer with a yes, it's a yes. If you can answer with a no, it's a no. Do not give anything else.
And what would you say about how would you prepare your client if they're trying to be too confrontational, if they're getting irritated by the questions that are asked by defense counsel? Because
Oh, yeah, I've had that. And I sometimes can anticipate which clients those are going to be. I prep them all the same. And the ones that I do think they're, that they can be, a little maybe rattled or agitated, I prep them even more and just say look, they ask these questions of everybody. Or by the way, I read your medical records and you told this doctor this and that doesn't match up with this. So what's going on here? I need to know, because I need to know as your attorney how to manage this. I tell clients all the time, they always, when you bring a personal injury claim, not everything is an open book, but they're going to ask you, have you ever been convicted of a crime? We manage how a client can answer that, what they can say and what they don't have to say. Have you ever filed for bankruptcy? it's all very important. If you're cuckoo for Cocoa Puffs and you get outraged at the smallest thing, I just need you to act normal and neutral for like 3 hours, because the second a deposition ends, a defense attorney writes a report to the insurance carrier who's their client, and they say, "Dear insurance carrier, Melanie was unpleasant. A jury will hate her. I already know how to get under her skin, and I can ask her these questions to make her go off in front of a jury and make a jury hate her at trial. So let's not offer money, or if we're going to offer money, let it be a low offer, because I think we can definitely get a verdict against her at trial." They do that. They write reports. You want the report to say, "Dear insurance carrier, Veronica was a true gem. She's a
Settle the case.
Yeah. Now, a jury will love her. Give me money so I can settle the case. XOXO, so-and-so, attorney so-and-so."
Right. Just to go off of what Alex just said, it's not just about what you're saying at a deposition that matters, it's your behavior as well. So the defendants or insurance carriers, they're looking at how you react. And if they think you have like a short fuse, they'll be like, "Hey, I could use this at trial. I could just say the smallest thing and this guy's going to go off, and the jury's just going to look at him like, why would I pay this guy any money?" So it's not just about what you say, it's how you're presenting yourself and how you're reacting to the question. So it's very important to stay calm and just answer the question that's posed, because your deposition is not being taken for your benefit. It's there to give the defendants answers. It's their exploration time. It's not yours. So the best thing you could do, stay calm, just answer the question, and the faster you get out of there, the better for your case.
So based on all the information you guys just gave me, it sounds like you spend time with your clients to prepare them for their depositions. That means that we're experienced, we know what we're doing, we're the right attorneys to call. How long would you say you prep a client for their deposition? Is it days? Is it an hour? How long do you take to spend time with your client to fully prepare them for their deposition?
The standard for us is typically 2 days, at least 2 days of prep time. And I like to break it up between days, because you introduce the deposition to the client, they get to understand what's going to be asked of them. And then the second day of prep, they're more comfortable understanding, and we get deeper with them, right? Because you don't want to just throw everything at them at once, because at that point they might not be absorbing what you're saying. So I try to break it up so that they're absorbing the information. I don't talk to them just to talk to them. I need them to absorb what's being said so they understand it. So for me, it's at least 2 days. Bigger cases or cases that I think might have more involvement in it, I probably do more preps. And some clients really do just need more preps because it's a very emotional thing for them. So standard is 2 days, but sometimes it could be more.
I agree. I prep clients at least twice, even on what someone would call a simple car accident case, at least twice, because one is an introduction, and I also want to give them enough time after that introductory prep to go home and think about things and reflect, and then oftentimes they come back the second time and say, "Okay, how about this?" Or, "Can I answer this way, and this, that way?" I want to be able to say X, Y, and Z, and that way we have time to go through it. But yeah, even on the simplest car accident case, if I had, a case where liability is disputed, it's not a rear end car accident case. Let's say it's a T-bone. I had someone coming out of a fast food restaurant and someone drove up and turned straight into them. And there was a claim that, my client didn't take evasive action. And so I said, how are we going to handle that? When did you first see the car coming? "Oh, I think I saw the car like 10 seconds. I was like, 10 seconds? You really think it was 10 seconds? Yeah. I'm like, but how? I said, how much time? Instantly, like 10 seconds. So I said, take your phone out, put on the clock, and put 10 seconds and tell me it took 10 seconds. So I don't think you realize how long 10 seconds is in that scenario. It was not 10 seconds. It was less. It was probably 1 or 2 seconds if they just turned right into you. 10 seconds, and you're not going to lose the case, but it surely does not help. So it's going over things like that. It's pulling up Google Maps. It's pulling up, what an aerial view. I go on Google Earth with my clients. I go and I look at Google Images. I look at their pictures. Sometimes, depending where an accident happened, we've already done, public information requests where we get surveillance cameras, we get police investigation reports. We go over everything. And I always tell my clients, I hope you don't get sick of me, because this is really the time for us to get to know each other as well. But I'd rather over prep you. I want to make sure that you don't hear a question for the first time at your deposition. I want you to hear it from me first. And I've had plenty of clients who walk out and say, we walk back to the parking lot together, to the train together, and they go, wow, she really asked me everything in the order you said they were going to ask me. I said, I know. I hear these all day, every day. So I know what to expect. We know what to expect, and we just want to make sure that our clients are comfortable in a very stressful situation, that they're best equipped to handle it.
And just to add to that, because you asked us how many days do we take to prep the client. So we say 2 days, but we're prepping ourselves before we prep the client,
course.
right? So it's at least 2 days for us to prep ourselves, going over all the evidence, going over any videos, photos, medical records. We're doing this prep before we prep them, right? So a deposition of a client, although it might be like a couple of hours, that's like a week at least of prep work by your attorney. And if you have experienced attorneys like us, we're doing that prep work. An attorney should never just show up at a deposition with their client and just sit there and let their clients answer questions.
Yeah.
That is just not okay. So the right attorney matters. I know there's a million attorneys out there, but getting the right attorney truly matters. Someone who's actually going to devote the time and effort into your case.
And isn't the plaintiff's deposition like a critical part of the case, their testimony?
Yeah, it's very critical. The plaintiff has the burden. You bring a lawsuit, you need to prove it. It's very critical because, one, it's sworn testimony, so it's be held against you under penalties of perjury. And then as I have a lot of motion writing background and I have a lot of appellate work background, when I prep my clients for depositions, I'm already thinking about motion practice. I already look up what's the case law that I think applies to my case and I want to use either to prove, because in certain cases you can prove or try to prove on summary judgment motions that a judge can award a decision to you right now, there's no need for a jury. Or in certain cases, like oftentimes slip and fall cases, the defense is going to make a motion. So let me look up the case law about that, and what do I need to make sure my client gets out at deposition that'll deny that motion in the future. Plaintiff's deposition is not only important because it's sworn testimony that's going to be held against you 3 or 4 years from now when you finally get in front of a jury. It's also very important because it needs to corroborate what's in the medical records. It needs to bring out, what we call liability, who's responsible, that, if the plaintiff is at fault, if they are, how much that is. And then two, what we call damages is, the biggest part of your case is damages. Well, I shouldn't say biggest. We only get to damages and we prove liability. But damages is why you picked up the phone and called somebody because you got hurt. So it is important. It's one... coming out of law school there, about 10 years ago, some people don't take plaintiff's depositions that seriously. It's let's send the new kid on the block, he or she can object. You don't want to do that. And you certainly don't want to be meeting the attorney sitting with you at your deposition for the first time 15 minutes before. It's very critical. Everything flows from the plaintiff's deposition.
Great. All right.
So don't it up.
That ends that segment.
That ends that segment. All right.
Okay.
We're going to play another segment right now called Myth versus Fact. All right. You don't need a lawyer for a minor accident. Myth or fact?
Myth. You should always call a lawyer. Even if it's a minor, what is a minor accident? I wouldn't even know. I mean, if you feel hurt enough that you're looking for legal advice, that's certainly not a minor accident. It's because if you're not sure, at least you can get clarity. If you've as we spoke about earlier, you might not feel injured, but you might go to the hospital or urgent care that day and they say, look, you're a little bruised and swollen. We don't see anything on an x-ray. There's certainly no fractures, but that doesn't mean that there's long-term, sprains and strains and herniations, things like that won't get picked up right away. Well, not herniations, that would get picked up.
I would just say myth.
Yeah.
Because even the smallest fall can cause a big injury. You never know unless you get checked out by a medical provider and call an attorney.
And there are times that we have cases where we start it because we're not sure if there's a case, but it turns out later on that thankfully the client is better. There are no injuries.
Right.
So it turns out not to be a case, but I think it's always worth making the phone call to a lawyer.
Yeah, because the answer is always no unless you ask. So you might as well ask. And oftentimes you learn about, short deadlines you want to be aware of, things like that, to get your medical bills paid, to submit a claim against the city or a government entity. There's a lot of things in the background that you may not be aware about unless you contact an attorney. So there's, especially, where we're doing free consultations, there's really no harm. There's
no reason not to call an attorney.
Good. Next question in myth versus facts. You have to accept the insurance company's first offer. Myth or fact?
Myth. And it's actually frowned upon to accept the insurance company's first offer. If the insurance company is making you an offer, you should be contacting an attorney right away, because that's usually a red flag. Is it a red flag?
Well, yeah, it's
a red flag that you have a great case and they're trying to get this case resolved without you speaking to an attorney, because once you speak to an attorney and they assess the case, they're going to know your case is worth a lot more and tell you to decline that offer. So that's definitely a myth. You need to contact an attorney, especially if they're making an offer. Just never accept the first offer.
Yeah, I would never accept an offer without speaking with an attorney first. If there's a first offer, there's another offer, and there's probably another offer behind that, and there may be even more, depending on which attorney you hire. Who you hire matters. Insurance companies keep files on every single attorney and firm that they've ever encountered. They know Joe Schmo takes lowball offers. They know an attorney at Awad Baker is someone who's ready to take this case to trial. So it does make a difference. So it's a complete myth. Don't ever take a first offer. I wouldn't even talk to an insurance company, even your own, because your insurance company is your friend until they're not. And because sometimes you have your own policies that can help supplement what you get from someone else's negligence, that they hurt you in a car or something like that. If what they have on their policy is not enough to cover your injuries, you may be able to tap into what you have on your policy. And now your insurance carrier, who was your friend, all of a sudden, you guys on this different sides of the V, right? And now, they're not your friend anymore. So they're just looking out for themselves. And that's why you need to look out for yourself and call an attorney.
Okay. If there isn't a lot of vehicle damage, you aren't injured. Myth or fact?
Myth. And I feel very passionately about this because I was rear-ended on the LIE and it did not look like there was any vehicle damage, because guess what? It was in 2024. Thankfully, we don't live in the horse and wagon era where the wagon would just explode upon such a strong impact. These days, cars are built to withstand strong impacts. That doesn't mean that you're not hurt. I still was pushed around in my own vehicle when I got hit. My dog went flying, and I got out of the car in the LIE, and the guy who hit me was like, "Oh, it looks fine. There's no damage." There was a little bit of cosmetic damage on my bumper, but on the LIE, I couldn't see under my car where the steel beam under my car was scrunched up, and my rear view camera was never the same after that. But it's a complete myth. Thankfully we live in, modern times where, technology, these cars are being built to, take that impact and not show it. That doesn't mean that the occupants inside the vehicle did not sustain an injury. You're still moving around. We have clients who hit the steering wheel. We have the airbag that deploys. We have a seatbelt strangling and, causing bruising and contusions. It happens all the time. So the short answer is myth.
Okay, great. The last question for myth versus fact is, do you only have a certain amount of time to start a lawsuit?
Fact. In New York and most states in the country, you have a certain amount of time in which you can start a personal injury lawsuit. For general negligence, it's typically 3 years. For medical malpractice, it's 2.5 years. And when it involves a government entity, you actually only have about 90 days to assert that claim. So it's very important to contact an attorney as soon as possible, because you do have a specific amount of time that you can file a lawsuit. And those, what I just gave you, were general time limits. There are other exceptions to those rules. So that's why you always have to contact an attorney, an experienced attorney, and not just ChatGPT, because ChatGPT doesn't always know all the exceptions to the rules and things of that nature, and the specific facts to your case, right? So a lot of times it is fact specific. So contact an attorney right away.
Yeah. Yeah, it's a fact. You can't just bring a lawsuit whenever. You have to bring it within a limited time frame for the most part. There are exceptions to that, calling an attorney would be important to go over with. But like Veronica said, the difference in time, it's called a statute of limitations. If you watch Law & Order, like who doesn't? But if you watch Law & Order, you hear about statute of limitations all the time. Especially on cold cases, 30 years ago, 40 years ago, that comes up a lot. Statute of limitations are out there. They vary by case. And as Veronica said, it's so fact intensive and specific that you need to speak with someone who knows what facts matter, which facts may shorten the time, which facts may lengthen the time, and what other paperwork needs to be filed. If you're suing someone, a private company or private citizen, there are certain SOLs, they call them, statute of limitations. If it's against a government entity who gets special treatment under the law, it's usually shorter. So it is important that you speak with an attorney, because if you miss the SOL, should I just curse?
You are hard.
Yeah.
You're shit out of luck.
Out of luck. So we're going to play a little game called Name That Movie. So I'm going to give, well, not me, but we'll go back and forth, famous legal movies with great lines. So
Okay.
we'll say the line and then we have to guess what movie it is.
All right. First movie line. Let's see who can get this. It's a classic. You can't handle the truth.
Ding. A Few Good Men.
Correct.
Now you give us one.
That's a movie, I know the quote and I've never seen it. Don't tell my father that.
It's a good one.
Wow.
Yeah.
I'm surprised.
Okay. Oh, this is a good one. Whoever said orange is the new pink is seriously disturbed.
Ding, ding, ding. Legally Blonde.
Was I pink when I said that? Because I feel heat. Okay. I'm Elle Woods and this is Bruiser Woods. We're both Gemini vegetarians.
Next line. Everything that guy just said is bullshit.
My cousin Vinny.
Yep, got it right. Did you watch that one?
Oh yeah, that one I've seen.
It's a classic.
Yeah, that one I grew up watching that one.
How am I gonna say this one?
You want Alex to say it then?
Yeah. You say it good, but then you're gonna
She
get.
likes this one.
Yeah, then you're gonna get.
This
paid.
one? Okay.
No.
No, I have a good one from my environmental law days. It's a good clue. By the way, we had that water brought in specially for you folks. Came from a well in Hinckley.
Erin Brockovich.
Yay!
I love that.
I'm sorry.
I have a tricky one for you guys. Winners don't make excuses.
I think I know that one. Is that from Suits?
Yep. Brownie points if you tell me who said it.
Harvey.
Yeah. So if you liked our content, just hit the like button, subscribe, and leave us a comment.
And if you've ever been injured in an accident or a wrongdoing for medical malpractice, give us a call.
It's free, it's confidential, and it could make all the difference. Give us a call today. Awad and Baker Law, 516-716-4444.
That was great.
Woohoo!
Hi,
I
guys.
think you're too pink on that one. I think we need to.
I felt it coming.
Just kidding.
All right.
All right, guys, great.